Hello and welcome to another exciting episode on the Law Lab. My name remains Aaron Asiedu Entry. Today we are looking at law of contract. Law of contract, specifically the introduction to law of contract. Specifically today we will be looking at the nature and essence of contract. The nature and essence of contract. And I have with me my colleague and a friend, one I call a brother. He's Daniel Odruminta, and Daniel is well known in the Gempa Law Faculty as Dateba. Dateba because he speaks, does things like Justice S.K. Dateba, as he was a justice of the Supreme Court, as he then was. And clearly, Daniel is well versed in the law of contract. So when we ascribe him to be Justice Dateba, then you should clearly know that he also have some very good knowledge in law of contract. Danny, welcome to the Law Lab.
Thank you very much, my
How
brother.
you doing?
God is good. We're managing.
Clearly, you are a testament to one who is married to a fancy woman.
Yes,
She's taking a very good care of you.
Very good care of you. Because don't forget, marriage is a contract.
Oh, okay. It is the only contract that you are giving the certificates of commencing.
Exactly.
I see. So, Danny, basically, the problem most law students have in our system is that when they are looking at various areas of law, say law of contracts, say equity, looking at immovable property law, it becomes very difficult defining the said area of law. So basically, when we talk of law of contract, can you tell us what law of contract is?
Okay. Thank you very much, Aaron Asiedu Entry once again. I think that I need to first and foremost appreciate the Law Lab platform.
Right.
And I want to recommend it to all students because primarily when you go to school, one of the most interesting things is to get some of these things to enable you understand what you are taught in class. So I would say that the Law Lab platform is one that all students should use and also recommend to other people. And you've done very well in introducing the Law Lab platform. Beyond that, I also want to establish that anytime that they ask you what is contract law, what is company law, what is constitutional law, you should not forget that these are two words that have been joined together.
Okay.
And so just separate them and simply define contract law as the law that governs contract. Simplicity.
That is too simplistic. Now, the point is, most of us know what law means because I remember in our legal system class, Mr. Kla, who was then our lecturer, clearly, Kla is a lawyer, so we should actually establish that fact.
Yes.
He actually asked us what law is. And what I did, my take out of the class was what Professor Oliver Wendell Holmes, who is called the great dissenter, defined law. He says law is a prophecies of what the court will do in fact and nothing more pretentious.
It's true.
So for law, we know what law is.
Good.
Now, the base word that needs to be explained proper is a contract. So when we talk of contract, what is a contract, Daniel?
Okay, thank you very much. And so I think that is the substantive matter that we are here to learn. What is a contract? I'll first and foremost want everybody to know that in our everyday activities, we enter into contract. Every day. Anytime you exchange money for something, you've entered into a contract in one way or the other.
Okay.
But the most important thing that you need to know, which was established by Sir Frederick Pollock, was that a contract is a promise or set of promises for which the law will enforce.
Okay.
Which means that there are promises or set of promises that the law will not enforce, and we cannot deem that as a valid contract.
Wow.
So as you sit out there and we are getting the understanding, take note. Sir Frederick Pollock is saying that a contract is a promise or set of promises for which the law will enforce.
Wow.
But I will not want to end there.
Okay.
American Restatement of Second Contract will say that not only is it a promise or set of promises for which the law will enforce, but take note, for which if you breach that promise, the law provides a remedy. Or if you perform your promise, it becomes a duty. And so you have to understand contract holistically and not only in one way, so that you take note that in your everyday duty, if the nature and essence of that contract is one that the law will enforce, be careful, because if there is a breach, there will be a remedy. And if you perform, it is a duty. That is contract.
I think any businessman will be interested in the breach aspects,
Great.
what the law will do, and indeed, if there is a remedy, then that is a good one.
Great.
Well, we all in this legal space appreciate that law thrives on principles.
That's true.
I remember in our constitutionalism class, we were taught that there are principles of constitutionalism that actually limit public power.
Yes.
Now, if we talk of law of contract, are there some underlining principles of contract?
I think that it is very important for us to take note. Just like you said, the principles are very important. They form the baseline for you to understand the concept of a particular topic. And so in contract law, the underlying principles, the number one you need to know is what we call freedom to contract.
Okay.
Parties are at free will to contract. Nobody should force any party to enter into a contract.
Does it mean that if one, or let's say me, I enter into a contract, let's say under a threat, or when I'm forced to enter into a contract, that contract will not be enforceable?
Interestingly, this is what I want to recommend to the people who are watching us. The Law Lab platform is in sessions.
Okay.
One of the sessions, we will look at what we call vitiating factors.
Okay.
Which means that under certain instances, if you are forced into a contract, it will be unenforceable. I think that appropriately, when we get to that session, please remind me, we will take time and espouse on that.
For being able to give us a second endorsement, I confer on you a permanent membership on the Law Lab platform.
I appreciate so much, because
Very
I
well.
think that every student will have this thing as a pocket messiah.
Okay.
It's going to save you.
Okay.
And so I think that it is appropriate that
we are
everybody
humbled.
relies
We are
on it.
humbled.
Thank
Okay,
you.
so the first principle is freedom to contract. That you must contract at your own free will, right?
Yes, please.
So the next principle.
The next one is what we call the sanctity of contract.
Okay.
Which means that the binding nature of contract. I read biochemistry in Kwame Nkrumah University of Science and Technology, and so I understand the concept of chemistry a little bit, and which I deem that if you have sand, if you have stone, if you have water, without a cement, you cannot put up a structure.
Okay.
And so the adhesive nature or the binding nature in these things I mentioned is the cement.
Okay.
And so if a contract will be enforceable, then we should realize that the parties subjected themselves to be bound by the promise.
Okay.
The parties themselves. And so we have a way we mentioned, we call it this concept of the pact
Sunt servanda.
servanda.
Okay.
And so it is very important.
Right.
Then the very last principle I want to talk about is what we call the central notion of contract. What is the central notion of contract? It's the concept of bargain.
Right.
The concept of bargain. In other sense, parties are at free will to bargain.
Okay.
What then is bargain? A bargain is defined as an agreement for which it is a promise in exchange for a promise or performance of an act. And so I will make the promise, and then another party will have to exchange my promise with a promise or perform an act in exchange for my promise. And so that is what we call the bargain. And take note, it is the central notion of the three principles that we've mentioned.
So clearly, you've mentioned that there are three principles. First, we looked at freedom to contract. Second, we are looking at the pacta sunt servanda.
Yes.
That is, agreement needs to be kept,
Yes.
or the binding force of an agreement.
Yes.
And the last one is the central notion of central notion of a contract.
Yeah.
That is the concept of bargain.
Thank you.
Are you in a way saying that whenever there is a contract, all these three principles must be existent or must be found or seen in it before we can say that this contract is enforceable?
Great. Primarily, these are underlining principles or theoretical underpinnings.
Okay.
And so without them, the contract is unenforceable.
Okay.
And so we need to be able to primarily establish that we are at free will to enter into the contract. Number two, we as parties, we subjected ourselves to be bound by that contract. And then number three, we were at free will to bargain. And so they are underpinnings. You need all of them there. You need all of them there.
Okay. Is there, this law of contract goes ahead with case laws and others.
Yes,
So if
please.
these three principles
Great.
clearly making us understand that all of them needs to be present, I wanted that clarity because someone might say that we have three, so at least when two are present, we have majority.
Great.
But what you are telling us, all these three principles must be existent.
Great. So I think that it is important that people rely on Auntie Christie's book, Christine Dowuna Hammond, The Law of Contract in Ghana. It is the book that I'll recommend for every law of contract student. It is very important. And in that book,
in addition to that
okay.
book, one may also look for the book written by the founding dean of the UCC Law Faculty, Professor Bonzi Simpson. He later became director of GIMPA as the entire institution.
I think
and
that's
now he's back to, I think, UCC again.
Okay, that's a familiar name. So you need these books to rely on. The very first case that Auntie Christie's book mentions is the case of Bolton and Madden.
Okay.
And it will tell you that a naked promise is unenforceable.
Okay.
A naked promise. You cannot make a promise only, not in exchange for a promise or performance of an act. It is just to buttress the underpinning principles of contract. That that promise you are making, there should be an exchange by which somebody is also making a promise or the person is performing an act. So the first case I'm recommending that you put down wherever you are is the case of Bolton and Madden. The principle is a naked promise is unenforceable.
Just as you are mentioning promises, and we've clearly understood the principles underpinning or underlining what a contract is. My problem here is that you meet Openi Kwaju Menu on the road, actually exchanging some promises with Amma, not a platonic one or something that is leading them into a relationship, but one with a concept of contract. Is it necessarily that contract should be written? It should be oral, or these promises should be partly written? I want to know whether there is a clear format one needs to go with when he's actually formulating a contract.
Okay, great. I think that that's a very good one to bring in. Section 11 of Act 25, that is the Contract Act, provides that the contract must not always be written for it to be enforceable upon the coming into force of the Contract Act 25, which means that we can have an oral contract, we can have a written contract, we can have a partly oral or partly written contract. So long as it is evidence of the elements, it is a valid contract and it is enforceable. So take note, Section 11 of Act 25. Please put that one too down.
Very well. So clearly, as he mentioned Act 25, note that with regards to contract law, we will be heavily relying on Act 25. That is the Contract Act 1960, Act 25. Right. So now, we now know that contract can be written, it can be oral, it can be partly written and oral. My point is, on the third principle of contract, or the principles underlining contract, is the concept of bargain. And you said it is the central notion of contract. My point is, people are just giving out promises here and there. And at what point will the court be able to ascertain that in this particular instance, these two people or these two individuals are in a contract?
I think that it is very, very important we get to know. That is what we say, ascertaining the facts of an agreement. The court uses two tests. Two. Take note. The subjective test and the objective test.
They use both of them at the same time?
So we will develop it and we will realize that no. So the subjective test is what the courts you were previously relying on. And so when we talk about the subjective test, it is simply saying that the court will want to know the actual intention of the parties. They will enter into the minds of the parties to be able to know whether or not the agreement is one that is enforceable. And so we also call it the meeting of minds, or what we call ad idem.
Ad idem.
Ad idem.
There was this friend of us in our class called Divine Salo. The guy has a lot of Latin terms in this one. It is the first Latin term he mentioned to me before we entered into class. Ad idem. That is meeting of minds.
Meeting of minds. That means that I want to know the actual intention of the parties. Cases like Short and Morris and also Hartog versus Collin and Shields will help us ascertain the concept of addendum, or I would say that the meeting of minds or the subjective test at play.
Okay.
And so in Short and Morris, which we will see in immovable property, and that is why I keep repeating that, please make sure that every session that the Law Lab platform shares, you go and look at it. I'm sure immovable, you talk about
and
it.
like and share it with your friends.
Great. Because I am sure whoever will come in will expand on it. Short and Morris is a case that is evidence of parties being at cross purpose.
Okay.
So the court says that no, your intention, your actual intention is different from what you are doing. And for that matter, it will be unenforceable. But they looked at the subjective test.
Okay.
The subjective test. Another case is Hartog versus Collin and Schultz.
Okay.
Hartog versus Collin and Schultz too, the court looked at the actual intention because premise on the course of dealing and the custom, when they were selling skins, it was quoted in per piece and not per pound.
Okay.
But then this case, the offeror quotes per pound, not in per piece. And then the offeree takes advantage. The court says that no, the actual intention is not there. And so the subjective test is one that they rely on. However, entering into the minds of people is difficult.
Before, meaning you want to move from the subjective
I want
test
to move
to the,
yes.
But before that, you mentioned the word offeror. It is a bit technical.
Yes.
What is the meaning of an offeror and an offeree?
Okay. In simple terms, an offeror is the party that makes the promise.
Okay.
And an offeree, just like we were discussing in our free time, is the one who is receiving the promise. Okay. But you are not only receiving the promise, you're going to perform either an act or in exchange for that promise by the offeror, perform a promise or give a promise. Let me use that word.
Okay.
And I said that
the offeror, in simple terms, is the giver, and the
giver of the promise
is the one
the
who
receiver
is at the
of the promise.
end, and he either receives by giving another promise or performs an act. I get you
Simplicity.
now. So the first test you've made us understand is the subjective test, and you use the case of Short and Morris and also Hartog versus Collin and Shield.
Great.
What is the next test?
Okay, the next test is what we call the objective test.
Right.
And the objective test, we are looking at the outward appearance.
Okay.
What are they doing? What is the conduct of the parties? That is what the court will rely on. I say that in modern day, that is what the courts usually rely on, the objective test. Because what are you people doing? That is evidence of the contract that you want to, you entered into. And so you realize that my most favorite case, the case of P.Y. and Sons versus Kingsman.
Indeed.
Yeah,
I don't know whether you have proprietary interest in that case.
Yeah. It is a very interesting case. I recommend that you read it extensively in the book of...
It's a Ghanaian case.
Yes, it's a Ghanaian case. Auntie Christie briefed it so well.
Okay.
But in P.Y. and Sons versus Kingsman, just to give a simple brief, P.Y. and Sons entered into a lease agreement with the government for 50 years. Then P.Y. after using the property for some time, also enters into another lease agreement with Kingsman. But then when you look at the document, it was evidence of an assignment.
Okay.
That notwithstanding, there were certain covenants in that conveyance.
When you talk of assignments, what do you mean?
Okay, so in simple terms, immovable property will tell you that assignment is where the remainder years or the remaining years are wholly transferred to another party.
So I think we will further explain it in our sessions with immovable property, but that is a basic understanding of it.
But then a sublease is where you transfer the remainder less a day.
So I think less a day is one part of it, but you are not transferring all the remainder years.
Absolutely.
You leave some of the years.
You leave some of the years. Great. And so in such an agreement, you are still supposed to report to the lessor who gave it to you.
Okay.
And so in their action, Kingsman was performing everything that P.Y. required of Kingsman in the agreement. That was what was happening. Now, it so happens that after some time, Kingsman says, I won't continue again. I'm not going to respect you as the lessor because I deem the contract as an assignment and not a sublease. P.Y. quickly goes to court to amend the appendum less a day.
Okay.
At the trial court, it didn't go well for P.Y. and Sons. At the Court of Appeal, same. Then P.Y. goes to the Supreme Court. And in the Supreme Court, this is what they say. They say that, see, you were timeous And so because you were timeous, we are going to agree. And that is because they looked at the objective test. What did they say? They said that per the conduct of kinsman and piwata, the agreement is one which is evidence of a sublease and not an assignment.
Okay.
And so in that case, which nobody should forget, it is a case you cited and you use it for objective test. Per the conduct and appearance of the parties, it is evidence of a sublease and not an assignment.
Remember the Supreme Court actually stating that where it is obvious that any reasonable person will know that these parties are in agreement, meaning the parties will be bound to it and you cannot just run away from it. So the objective test, what you are saying clearly talks about the reasonable man test. What the reasonable man will see that you are into is what the court will appreciate, that indeed that is the objective test.
Precisely.
Is that the only case you would want to talk about under the objective test?
Okay. Under the objective test, there are certain questions that the court will raise, or certain questions that are asked. The first question I want to talk about is whether or not the words, or where the words are clear and unambiguous, what will the court do? The court will enforce the contract.
Okay.
Because in that instance, the case of Tamplin and James is a good case. If you remember the case of Tamplin and James will tell you that it is not what you thought. It was so clear that the auctioneer was referring to this particular property.
Yes.
Everything was clear.
I call it the Lord's case.
Exactly. And you were saying when you were young, you knew that the property had these extensions all being part. The court says that it was so clear, it was unambiguous, and it is enforceable. And so that is one of the questions. Another question is where the words or statements are unclear and ambiguous, what would the court do? There are three very interesting cases I want to talk about.
Okay.
The first case is what we call the case of Raffles and Witchell House. I call it the PLS Bombay case. Was it going to arrive in October? Was it going to arrive in December? It wasn't clear. And the ship was named PLS. One ship, it's arriving in October, and it is also arriving in December. Clearly, it was unambiguous. The courts cannot enforce it because which one are we enforcing? The next case
it's rather ambiguous.
It's ambiguous.
Yes.
It's ambiguous.
Yes.
Then the next one is what we call the case of Falk and Williams. We call it the code case.
Yes.
Because the code depicted it being moved from Fiji to
I think Barcelona.
To Barcelona, I think so, or maybe Sydney to
So Fiji to London also.
Okay. So you realize that the code was depicting two different things at the same time.
Yes.
The court says that which one are we going to enforce? Then the case of Scriven Bros versus Hindley. One lot is saying hemp. Another lot, another one is talking about toll. But then the party thought he was purchasing hemp and not toll. The court said that it was ambiguous. And so in such instances, the court will look at the words and statement and see, was it clear and unambiguous, or was it unclear and ambiguous? Another one that the courts will look at is where we say apparent contract.
Okay, what are they?
When we talk about an apparent contract, we have the cases of Frederick E. Rose and Pym, and then we have the cases of Addison versus A.S. Norway Cement.
Okay.
In all these cases, you realize that the quality of the subject matter is what is ambiguous to the parties.
Okay.
However, the terms and then the subject matter, they are not mistaken with. In Pym and
Frederick E.
Rose and Pym, you realize that they were talking about Fevros and Moroccan husbands.
Okay.
But the truth of the matter is that the subject matter was exactly what you had. It was only the quality of subject matter that was in contention.
Okay.
The court said that apparent contracts are enforceable.
So they are apparent on the face, so you cannot come and just
absolutely
around that.
Absolutely. So the concept of objective test with these questions that I've mentioned are sufficient for one to be able to understand the nature and essence of contracts.
So basically, you've taken us through to appreciate what law of contract is, and you actually broke it into two by appreciating what law is and even what contract is, relying on Frederick Pollock, and also the American Restatement second contract.
Yes.
We moved ahead to understand the underlining principles of contract by stating the three underlining principles of contracts, i.e. freedom to contract, looking at sanctity of contract and also the
concept of
central
bargain.
notion of contract, that is the concept of bargain.
Yes.
Then we move ahead to appreciate the types or the forms in which a contract can take, either written, oral, or partly written and oral. We moved ahead to appreciate the fact that when it comes to contract, the court actually uses two tests, i.e., the subjective and objective test, to ascertain whether the parties are in an agreement. And that is what we've looked at up till this time. So we now appreciate the nature of contract. But you see, as we know that law thrives on principles, with regards to contracts, as we know the principles, are there some elements that we should expect or see in a contract for it to be a valid contract, meaning that it can be enforceable by the court?
Okay, so thank you very much, Aaron Esidwentry. I will say that indeed you are right. The contract validity is premised on the elements.
Okay.
So take note. We have other people will say 6, others will say 5, but I'll list them and you yourself, you count them. The first element is what we call offer. The second element is what we call acceptance.
Okay, most people join them together.
Most people. So we continue. So offer, acceptance, intention to create legal relation. The next one that I want to talk about is what we call capacity.
Okay.
Then the very fifth one, which is very, very essential, is what we call consideration.
Okay.
That notwithstanding, other people will add vitiating factors, absence of vitiating factor. There should not be any vitiating factor which will negate the existence of these elements to make the contract enforceable. So these are the elements that I believe in subsequent sessions,
Sure.
I will take my time and expand on each of them for everybody to appreciate.
Right. Thank you very much, Daniel. I think it's been an exciting one. Now, in our subsequent videos or episodes, we will be taking the element of contract seriatim, that is one by one. And it's been an exciting one, of course, and we are most appreciative of your time coming in. We are hoping that subsequent times we will see you as you take us through the element of contracts, as you've already promised. Remember, I've always been saying this: do not take all your matters to court, take some to your lawyers. You get it? Because your lawyers also need to eat. Thank you very much. This has been the Law Lab, and we shall see you in the next episode. Thank you.